So this week I'm going to do things a little different. Instead of going individually through each slide, I'm going to give you kind of an overall view while going through the slides. So hopefully it'll condense the information a little bit. But I want you to continue to read the chapter as well as look over the slides because that's what your quizzes are based on. So just because I don't hit a point doesn't necessarily mean it's not important, okay? So we're going to look at the defense. So obviously the other side of the prosecution, they're a lot more stringent on their ABA professional responsibility rules that are set out by the American Bar Association, as well as the conduct for professional responsibility here in California. And there are very specific rules that are implemented to defense attorneys. Some of them you're probably not going to agree with as much as others. ABA talks about all of the rules, and these are outlined in your book on page 66. You want to not assist in the unauthorized practice of law. You want to preserve confidence and secrets, exercise independent judgment, and improve the legal system. What does this mean? Well, it means that as a defense attorney, you have to do what's in your client's best interests. So if they tell you where they hid a body, you are under a legal obligation to not divulge that information unless they give you the go ahead to say so. The only time you're able to act against their best interest is if it's a moral obligation, meaning you would lose your bar license, or it would stop a crime from happening. So if the individual says, I come to you and I'm going to go kill my husband for insurance money, you can call the police and the authorities to stop her or him from doing that. But if it's already done, you must act in your client's best interest. The Sixth Amendment gives us the right to counsel, and you can be your own counsel. So self-representation. In your book, it looks at the case of Illinois v. Allen, Ferretta v. California. In fact, there's been some high-profile cases where the individuals acted as their own legal counsel. The old adage that talks about representing themselves in court has a fool as a client because they're not well versed in the trial or criminal law in general. And that can cause some significant issues in their defense. Again, we've talked about attorney-client privilege. You must be competent to protect your client's best interests, meaning if your client is on trial for a death penalty case, you would need to have some history or some experience in death penalty cases. You can't just take a case and hope for the best. If the individual feels that they have ineffective counsel, they are able to file a complaint, and they can actually bring that up on appeals and get the case remanded back down for ineffective assistance of counsel. And that could be something as easy as not having a witness take the stand that maybe should have, or leaving out evidence that maybe could have helped your case. And there is the Strickland standards. These are come from the case of Strickland. And did it undermine the process to the degree that the trial outcome is unreliable? Would the verdict be different? So there's a lot of different cases. I know one Serial podcast comes to mind. They claimed that Adnan Syed had ineffective assistance of counsel. Essentially, his attorney didn't go interview people that she should have, that could have created an alibi witness, and he was found guilty of the murder of Hae-Min Lee, his girlfriend at the time. And had she gone and interviewed those individuals, maybe the outcome would have been different. And then you have a right to trial by jury. Again, remember, you can always pick to have trial by judge or a bench trial and not have a jury. What would be the benefit? Well, sometimes if there looks like there could be bias, with a jury, then maybe you would choose to have just a bench trial and take your chances there. And then they're going to look at provisional counsel. So provisional counsel is essentially somebody assigned to the case. Oftentimes, they're not attorneys. It could be an individual that takes over for a time and helps guide you through the process to get to when you can have an attorney. And it looks at the idea of public defenders versus private attorneys. And oftentimes public defenders get a bad rap because they are overwhelmed, they have a lot of cases, and people tend to think that they encourage individuals to plea out. That's not necessarily the case. There's very, very highly skilled attorneys in the public defender's office, but oftentimes they get a bad rap. And then what is the defense supposed to do? So obviously they're supposed to faithfully represent their clients. They are supposed to admit evidence. They're supposed to negotiate. They're supposed to vigorously cross-examine and do what's in the client's best interest, whether that be a plea bargain or not. Again, faithfully, we've already gone over these, and vigorously attacking the prosecution would be making sure all the evidence is in, questioning all their witnesses, and bringing any reasonable doubt up as to the defendant's guilt to ultimately get them off of the case. And then negotiating with prosecutors, we covered vigorously cross-examining or using legal means to defeat the government. So how would you say vigorously cross-examining? Well, you want to make sure that you ask all the appropriate questions to question that individual's rationale for being there. Did they take a plea bargain? Do they have a personal vendetta? You would want to highlight all of that out. And then lastly, we're going to look obviously at defense misconduct. So is there issues that would cause the defense to be held in some sort of misconduct? And again, it's a little bit different than the prosecutors for the sheer fact that defense has the obligation to the client to act in their best interest. You could know your client is 100% guilty, and you are still obligated to act in their best interest to not divulge any of their personal information and to make sure that you act appropriately. Discovery just basically means bringing everything to light that is in the benefit of your client. But you also must disclose all information to the prosecution. And types of evidence, there's direct, conclusive, derivative, and circumstantial. These are all in your book, and they talk about the types of evidence that help with the innocent or the guilt of the individual. And then remember, the defense's only obligation is to prove beyond a reasonable doubt that the individual, by a shadow of a doubt that the individual is innocent. So if there's one little iota that's reasonable, the defense has done their job. So we work in a system where you're innocent until proven guilty. The prosecutor has to prove all of the elements of the crime. Defense can also use affirmative defenses in theory or in light of the individual maybe killed their husband, but they were acting under duress or necessity or self-defense. And that would be an affirmative defense that would likely get them off of the heavier charges, potentially could be a lighter charge, say manslaughter or a total defense, depending on the circumstances. And they would need to bring those forth. Again, and this is just going over all of the affirmative defenses: insanity, intoxication, coercion or distress, and then necessity, alibi, entrapment, defense of property, ignorance or mistake, and lastly, self-defense, which obviously is the most prevalent in our judicial system and the most used affirmative defense.